Today's webinar is ADA Title II Deadlines and Legal Risks, Leadership Steps for 2026. This webinar is produced by UsableNet, and today our featured presenter is joining us from Seyfarth Shaw. It's my pleasure to introduce John Egan, and I'll let him go ahead and introduce himself.
Thanks, Bethany. I'm so happy to be with all of you today. My name is John Egan. I am a partner attorney at the law firm Seyfarth Shaw, where I specialize in all manner of disability access and accommodations matters, effective communication, digital physical accessibility, service animals. I focus in the area of public accommodations under ADA Title III, as well as under ADA Title II, the accessibility obligations of state and local government departments, agencies, and entities. I'm currently the chair of the Disability Law Committee of the New York City Bar Association's Disability Law Committee. And I'm just so happy to be with all of you. Thank you in advance for your time and attention. Brooke.
Thanks, John. Yeah, thank you all so much for joining. My name is Brooke Porter. I am part of the business development team here at UsableNet. I also am been with the company for about 10 years, so been in this space for that long as well. And my focus is working with public agencies to ensure that they have the right strategies around digital accessibility, and that can mean a lot of different things. So excited to kind of dive into that today with John, both from the legal capacity, but then also just more practical steps on how to ensure that you are thinking about accessibility in the right way. So yeah, we're very excited to host this webinar today. Bethany, do you want to go to the next slide? Awesome. So just to kind of set the stage of what we're going to cover today, really we want to just kind of level set in terms of what the requirements are under the Title II and what the deadlines are as well. Then we will walk through some of the existing requirements for effective communication. John will be going through some of that. Also, what is covered. So what do you need to do to ensure that what things are required to ensure that are accessible, and what that really means. And then we'll go through more about the general and specific exceptions. John will be handling a lot of that. And then lastly, it's around what are we going to be doing about it? So what to do now, and really putting together some practical steps in ensuring that you have a right playbook on how to address accessibility for this new deadline that's going to be coming very soon. And then we'll spend the last 15 minutes just going through a quick Q&A. But feel free to filter in questions as we're going through this, as Bethany had said. So what is Title II, and really what are the new requirements and deadlines? So this DOJ ruling was issued in April of 2024, and it really there's kind of two deadlines within this. So by April 24, 2026, for any public entity other than a special district government with a population that they're serving over 50,000 or more, they need to make sure that any digital asset that they have is accessible to everyone, including people with disabilities. We'll go into more specifics on what that means. But then next 2027, it's the population of 50,000 or less. So anybody that has a county or something that they have less than 50,000, then they would be required to be accessible by 2027. Understand that 2026 is coming very soon. So thinking about how you're going to address this now is really critical, because we've seen countless times that it can take months to even years to address everything that needs to be accessible. So thinking about this now and joining this webinar is a really proactive step in doing that. So what is covered? This is very high level, but essentially any content that is posted online that is done by your public entity, that being public schools, any state and local government, police departments, courts, public hospitals and healthcare, any park and recreations, libraries, anything that is a government entity needs to make sure that any services that they're posting online is accessible. So, your tax bills, if you have for education, just making sure that your main website is accessible is also, super critical, but also your bookstore, you need to make sure that that's accessible. So it can really be anything that you all are putting out there. And also, it's important to note that it's any vendors that you work with. So if you work with third parties that are utilizing, like maybe you have that for your pay a bill for your taxes or whatever it may be, you need to make sure that they are also accessible as well, because that is a requirement. And we'll go into that a little bit more as well. But that is kind of what is covered at a high level. And I'll pass it to John to move through this more.
Okay, super. Okay, so let's step back and talk about, before we deal with this particular slide, the general framework for ADA Title II. So ADA has three titles. The first title concerns the employment relationship. The second concerns state and local government entities and their subdivisions. And Title III talks about places of public accommodation, covers places of public accommodation, hotels, private schools, retail stores, things of that nature. Okay, so within this framework, and we're going to focus today on ADA Title II, and specifically, as Brooke correctly pointed out, the new regulations requiring that state and local government entities provide accessible web and mobile app content, subject to a number of exceptions and exclusions that we're going to deal with today. Just also by way of background, not going to be giving legal advice specifically, but talking about what these new regulations say and what they will mean for covered entities. We're going to be pretty high level today. We could spend a lot of time, hours and hours, taking this apart. The regulations were accompanied by 300 some odd pages of commentaries, a lot of which I've went through. I'm not going to bore you with all of it today. We want to leave sufficient time at the end for questions. In terms of the content, we're looking at the regulations under 88 Title II. And we're also drawing on the DOJ fact sheet that was issued that accompanied the regulations, which I would recommend that all of you review because we find them to be very, very helpful in picking apart what these requirements are and what they are not. And we'll also be drawing on the regulatory commentaries that the DOJ issued along with its final rule, which, as Brooke correctly pointed out, for larger government entities is going to be required to be compliant in April, fast approaching April of 2026. So what does the ADA say broadly about non-discrimination as it relates to disability? Well, it deals with the concept that you cannot deny an individual access to your programs, services, and activities on the basis of disability. You have an obligation to provide on an equivalent, equal basis access to those programs, services, and activities. And you also have an obligation to provide effective access for individuals with disabilities to have equal opportunity to obtain the same benefit or reach the same level of achievement that's provided to individuals without disability. You can't segregate under the existing regulations and laws. You can't segregate by providing different or separate aids, benefits, or services to individuals with disabilities or to a class of individuals with disabilities under certain circumstances. And so there's a requirement of equivalence, integration, non-segregation, and access. Okay, and this applies to the wonderfully broad range of the disability community that exists, whether it's individuals with vision, hearing, cognitive, physical disabilities, disabilities of the hands. Right, there's a broad panoply of experience that's covered here, and so these are the broad requirements, and they would apply whether we're talking about the written, the written or physical aspects of programs, services, and activities of government entities, but also the digital. But the significant development here is that what the law now says by way of these regulations is that there's explicit obligations for state and local government entities to provide accessible digital content. This is required for federal agencies under Section 508 of the Rehabilitation Act, and now it will be required for state and local government entities under ADA Title II. It's not explicit under Title III. There's an interpretation, but now it'll be explicit under Title II. And so getting to this slide, what's covered? Okay, the expression of programs, services, and activities, and access to those activities that are made by contractual, licensing, and other arrangements. The focus is on content made available through these means. Okay, and so that's a significant thing because the obligation is not limited to the four corners of your website or your mobile app if you are covered. It also applies if through contract you're providing digital content elsewhere. Let's look at the example that's drawn from the DOJ fact sheet. If a city lets people park using a mobile app, that app must meet the WCAG 2.1 level AA, even if a private company runs the app. So, municipality enters into a contract for a third party to run an app to govern on-street parking, okay, or parking to a train station. Even though the entity is not developing that app, it has an obligation under these rules to make that app accessible. The standard, the Web Content Accessibility Guidelines, version 2.1, levels A and AA. What does that mean? The WCAG exists in multiple versions. The most current version is 2.2, but the requirement is 2.1. Levels A and AA, not AAA. A are basic requirements, AA are considered the standard requirements, AAA is considered aspirational. And the next slide, as you can see, there are exceptions to this obligation to make covered web and mobile app content accessible for what changes may be considered or what accessibility may be considered a fundamental alteration of the nature of the program, services, and activities, or what would cause an undue financial or administrative burden. Okay, so the requirement is WCAG 2.1, A and AA conformant, unless these exceptions apply. Significantly, the covered entity has the burden of proof to show at trial that these covered defenses apply. So it has to show facts, rationale, support for the position that not making something that would be covered is not WCAG conforming, that would be an undue financial and administrative burden, or it would fundamentally alter the nature of what government benefits, access, programs, and activities are being offered. And this is the same exceptions generally that's what's originally incorporated into ADA Title II. Okay, so it's generally consistent. Now, if you claim the benefit of that exception, there's a limitation on that, and that's what's at the bottom of this slide. You still have to the maximum extent possible, make the web content accessible. And so, for example, let's say that you have a web page with a map functionality or a map feature, and the map feature is provided by a third party, and you take the position that that cannot be made accessible because it's an undue burden or it's a fundamental alteration. That doesn't get you off the hook necessarily to make other aspects of that page accessible to the WCAG 2.1 A and AA standard. Okay, so you have to comply to the maximum extent you can, but except for these defenses. If you're going to claim the benefit of one of these exceptions, you have to do some things. The head of the entity, the head of your entity or the designee has to consider all the resources available for use in the funding and the operation of your program, service, or activity. Has to provide a written statement, and this is generally consistent with existing Title II concepts. Produce a written statement of all the reasons for reaching the conclusion that making said content is an undue hardship, for example, or an undue burden, or a fundamental alteration, and ensure that individuals with disabilities will receive the benefits or services provided by the entity to the maximum extent possible. So there needs to be a writing in your file from the designated individual that speaks to, what are the reasons for not making certain content accessible, relying on these exceptions. You may be asking, can I write that? Is that acceptable? Who writes it? So it's not clear in the regulations, but in the commentaries, DOJ says this. I'm going to quote them. The department, DOJ, has made clear that, that the determination must be made by a high-level official, no lower than a department head, having budgetary authority and responsible for making spending decisions. Okay? High-level official. This isn't part of the regulations, but this is the agency that issued the regulations. This is their interpretation. A high-level official, no lower than a department head, having budgetary authority and responsible for making spending decisions. That thoughtfully looked at this, considered the resources, and then made an express determination that something was not required to be WCAG conformant because of the exceptions. So the time is now to start interfacing with your organization to figure out what that writing is going to be and who's going to issue it if you're going to claim the benefit of these exceptions. Okay, so those are the general exceptions, and now we're going to go to the website accessibility specific exceptions, okay? Okay, so you have, you work, you're at this webinar, you're thoughtful, you're here, you're trying to figure this out, right? And you're probably thinking right now, my God, I have this huge website. If you're from one of those entities, I have this huge website, like where to start, what's covered, what's not. I have a lot of really old content. I have stuff that nobody's accessed in 20 years. Do I have to make all of it accessible? What's the lift, right? What do we do? There are certain exceptions you need to be aware of. And one is the archiving of web content. The concept here is, and this gets to a broader point about prioritization. It's very important in the website accessibility, mobile accessibility world to prioritize your work, right? It's very easy to get overwhelmed with the task at hand. You have to prioritize and you have to be strategic about how you use your resources to make website content accessible. Archived content doesn't have to be made accessible to the WCAG standard. You can still do it, but it doesn't have to be. And the point here is to reduce the burdens on your organization. And so you should take advantage of it if you can. What qualifies as archived web content? Well, it's got to meet these 4 requirements. 1, it was created before the compliance deadline, so before April of 26 for those larger entities. 2, retained exclusively for reference, research, or record keeping. In other words, it's not live, it's not active, it's not something that people would want to go to get access to your programs. It has to be stored. 3, stored in an area designated for archive content. You can't say that something's archived if it's just hanging out, commingled with everything else. It's got to be in a separate place. And it can't be altered or updated post-archiving. If you touch it, you own it. Okay? So it's got to live somewhere else, and it's got to stay inactive and not accessed, or not updated or altered in any way. The examples to the right. Here's where the exception would apply. A 1998 water quality report stored in an archive section, or handwritten notes that go along with that report, which are scanned and posted to the website in that section. So that's an instance where the exception would apply. Old report, it's a PDF, it's locked away in the archived section, okay? It hasn't been touched, it's just living there. The exception would not apply if, for example, you had city council meeting minutes that were created after the effective date. So you have meeting minutes, they're created in, I don't know, June of 26, and the meeting notes are, live on the site. Now you're in 2028. Guess what? Those meeting minutes needed to be accessible. That wouldn't be considered archive content. Pre-existing conventional documents. How do we define a conventional document? It's limited. We're talking about PDFs, word processor documents, i.e. like Word, spreadsheet files, i.e. Excel, presentation files, i.e. this PowerPoint, for example, a PowerPoint, that's made available on your website before the compliance deadline. Okay, so if it's a conventional document before the compliance deadline, you have PDFs of meeting minutes going back, 50 years, and it's on the website, pre-existing conventional document. Let's say you had a PDF of, using the examples, a Thanksgiving Day parade flyer posted on the town website in 2018. Well, that probably applies because it's a PDF, and it was made available on the site in 2018. An example of what would not apply is below. After the compliance deadline, the town posts a PowerPoint useful for an upcoming town council meeting. So just because you have a PowerPoint or a Word document or a PDF doesn't mean it doesn't need to be made accessible. That's a big deal, right? Because you probably have a lot of PDFs that need to be made accessible. But if it's pre-existing, right? If it was made available before the compliance deadline, and if it's not currently being used to provide access to public universities, public entities, services, programs, or activities, then it will qualify for the exception. Okay, this is a big one, right? Third-party content. I've learned in the last 8 years or so of diving into digital accessibility before that, and still I do physical accessibility work and other kinds of disability access and accommodations work. But I've learned that websites are not built with brick and mortar. They're not layered, right? There's no building official that comes and approves them. They are an amalgam of content that the owner is creating and third parties are creating and incorporating into the website. And so the question then becomes, what do you do about third-party content, right? There's a distinction in the regulations between content that is posted on your website by a third party and content functionality that is made part of your website or mobile app by a third party. So, using the examples, if you have a town message board, a town wiki, whatever, an individual makes a post, puts a PDF on there, and makes a post, adds content. That's content posted by a third party. As long as it's not being put there based on your sort of licensing, contractual, or other arrangements, it's not covered, doesn't have to be accessible. It's third party, they're posting this thing. Okay. But let's say you enter into a contract to have a scheduling feature where people can go on the website and schedule an inspection of some kind by a government official. And that is a functionality that you purchase, you arrange, you purchase for a third party to come in and provide that feature on your website. That's covered, right? That's covered. You have an obligation to pay attention to your content that is being acquired and incorporated into your access to your program, services, and activities, even if it's supplied by a third party. And so that gets to, I think, if you're a covered entity, what do your contracts say with your third parties? If you're a vendor who works with government entities, then that also requires some thought about what is your arrangement with your client, and what are the expectations that are going to be placed upon you to provide as a matter of contract accessible digital content to that covered entity that now has this obligation, not only for content that it's developing, but content that you, vendor, are developing and making part of the government website or mobile app. Okay. There was some discussion earlier about like sewer bills, tax bills, and so this is another like nuanced area that we want to talk about. There's an exception for individualized, password protected, or otherwise secured conventional electronic documents. All right. So there are three requirements for the exception to apply to this content. It needs to be a conventional electronic document as we've defined it. So PDF, PowerPoint, Excel, right? Word processing, presentation, or spreadsheet. It needs to be about a specific individual, their property, or their account. And it has to be password protected or otherwise secured. So the ability for a person to go on to, let's say, a town website and download their sewer bill, that ability, right, that structure has to be accessible. But the actual bill itself, the actual conventional electronic document that's downloaded, doesn't necessarily have to be accessible. And the reason why is because government entities are producing large numbers of these conventional electronic documents, and a number of people, a lot of people, the majority of people who are getting them, their sewer bills, don't have a disability. So for that reason, there's this distinction that's drawn. So look at the exception. A PDF of a water bill for a person's home that's available on the person's secure account on the city website, but doesn't it apply to the website itself, right? So if it's stuff that's applying to everyone on the site, that needs to be accessible, but these individual files that meet this definition that are about a specific account or a specific individual and that are password protected or otherwise secured, they don't have to be accessible. And again, it's these specific documents, it's not HTML as pointed out in the exception doesn't apply note below. Okay, social media posts. This is another big point. I mentioned earlier that the accessibility requirements aren't limited to the four corners of your website or your mobile app. They exist if you're making posts on other platforms. Social media posts on other platforms are covered. The DOJ, in its commentaries, talked about how they were impacted in terms of their thinking on this by public commenters that talked about how they get wildfire smoke notifications, they get toxic spill related information out to the public by way of social media. So you go on Facebook for your town and you see that there's an emergency and now you need to act. The DOJ says you're responsible for making sure that that content is accessible. That content is accessible, but starting on the compliance date going forward. So the question is, do you have an obligation to go back through all your Facebook posts, all your social media posts, and make them accessible? The answer is no, you don't if they're pre-existing. But on that day, right, in April of 2026, for government entities that are 50,000 or more, based on the US Census, your social media posts need to be accessible, meaning they need to be WCAG conformant. This is hazy because maybe the social media site isn't fully accessible, right? But to the extent that you can control your content, you, government entity, have an obligation to make sure that it's accessible as posted on a third-party platform. Okay, look at the example. 2017 social media post by a city sanitation department, the trash collection would be delayed due to a snowstorm. Okay, do you have to go back and make that accessible? No. Why? Because it's before the compliance date. Okay, there's a couple of other exceptions. We're getting to the end of the exceptions. And again, I don't want to harp on the exceptions, but I'm sort of speaking to the group of you that have, that are working at these for these government departments and are probably freaking out about, the scope of what you're obligated to do. So it's really important for you to, as a first principle, figure out what the scope of work is. Like, what is the content that I have to worry about? And what is its state of accessibility now? And where does it need to be? So that's the whole point of focusing on the exceptions. I think DOJ, based on their commentaries and based on their review of public comments, and I issued public comments, and another partner in my firm, they had to look at a lot of comments, and I think they're trying to sort of split the baby, so to speak, to try to come up with something that accounts for the burdens that are going to be placed on public entities to make this to make this a reality. All right. So okay. Um, there are a few other exceptions I want to cover. This concept of a conforming alternate version. Okay, this is a defined term, what we call in the laws a term of art, basically, under the existing W3C definition of the WCAG, the Web Content Accessibility Guidelines, right? These are guidelines that are issued by the World Wide Web Consortium, W3C. They publish them, they update them. They're an international organization, and they have defined what qualifies as a conforming alternate version. This is like another version of the website or the mobile app, but an accessible version. Okay, there's limits to what would qualify as a quote unquote conforming alternate version under the W3C's definition. But the regulations take it one step further. Not only do they incorporate that concept that you can have a conforming alternate version, but it's limited to those situations where, look at what the quote is, it is not possible to make web content directly accessible due to technical or legal limitations. That's a further limitation on the ability to use conforming alternate versions. Why? Because what's the temptation? The temptation is I'm going to make two websites. I'm going to have the disabled website for disabled folks and for folks that are non-disabled. Two websites. This gets back to what I talked about earlier about separate and unequal. Okay? Integration versus segregation. Would that alternate version be updated as consistently and as frequently as the other version? Probably not. Would that be inferior in some ways in functionality? Would that be inferior in some ways in terms of having the most recent information, the most recent functionality, the most recent features? DOJ is concerned that the answer to that question is no. And that's why they're limiting the exception in this way. Equivalent facilitation is another exception. It's drawn from the physical accessibility world, where there's this concept that you can have alternate designs or methods of accessibility, and it's accessible and compliant so long as it results in substantially equivalent or greater accessibility and usability. And so that's incorporated here. The example they give in the DOJ fact sheet we have for you here. There may be new web accessibility standards that are developed in the future, such as WCAG 3.0. Under this rule, a state parks department would probably be allowed to create a new mobile app for campground reservations that meet a future standard if the standard provides the same or more accessibility and usability than WCAG 2.1 level AA. So the concept is, regulating technology is hard because technology is always changing, right? AI is like an amazing thing, right? It's frightening from my perspective, but it's also amazing. And what is that going to do to our world here? And how may improvements be wrought for the public at large? I hope it's positive, and it may be. And so if there's new technologies that can meet or exceed WCAG 2.1 AA, then what the DOJ is saying here is that that will qualify as equivalent facilitation. And I promise you we're almost done with exceptions, and we're going to get to even bigger picture stuff. The last exception I'm going to talk about is non-compliance that has a minimal impact on access. This is something that yours truly advocated for in his comments, and you see in the actual regulation. I'm sure I wasn't the only one that basically advocated for this in comments. And the idea is this: what if you can't comply with WCAG? What if you can't do it? What if you have third parties that are producing some core functionality, and there are only two of them? I've heard this from clients. There are only two sources, and neither is accessible, right? What do you do if it's impossible to provide WCAG conforming access for any reason? You got to go back to why the ADA exists and what it requires, which is equivalence of transactions, experience, equivalence of access, integration, right? If the content is technically not conforming with WCAG, but is otherwise delivering an accessible user experience, I would argue, that's something that government entities and covered entities should have the ability to rely on, because there are some content that's just very difficult to make accessible in our experience. And if it's delivering the same benefits, the same user experience, then we would argue, and this is reflected in the regulations, it would be compliant. Now, this is a limited circumstance under the regulations, where there would be a minimum impact on access, and it wouldn't affect the ability of individuals to use the web content or the mobile app. There are requirements that to qualify, there needs to be substantially equivalent user experience in terms of timeliness, privacy, independence, and ease of access. What does that mean? The bullet points are for you here: access to the same information, engaging in the same interactions, conducting the same transactions, and otherwise participating to the same degree in the benefits, programs, and services and activities as an individual with a disability. The regulation commentary gives an example, and the example is, all right, there's an online, tool, right, and it's not accessible. There's an online form, and it's not accessible for people with dexterity challenges. Okay, now that person with a dexterity challenge can't fill out the form, so they call their friend, and their friend helps them. I'm paraphrasing. Their friend helps them submit the form, and the form gets submitted, and it's approved. Can the government entity say, hey, wait a minute, I know that form was inaccessible, but this form was submitted and we granted the approval for this individual, and so we should have the benefit of this exception? I think DOJ says no, right? No, because what steps did that person have to take that a person without the disability didn't have to take, right? They had to call a friend, they had to take more time, they had to engage in more back and forth, and they needed to ask for help. The whole core of this concept with digital accessibility is independence. It's being able to give people the ability to do the same thing that people without disabilities can do in an increasing online digital world. That's the point. And I think at this point, next slide, we're going to hand it back for big picture stuff to my friend Brooke.
Yeah, thanks, John. That's super helpful. So I know that was a lot to cover, but really we want to focus the rest of the call and then into Q&A about what do you want to do now. And it's a big challenge in terms of how you want to prioritize. And that's why we keep talking about prioritization. We understand, especially if you're education or if you're government, whatever it may be, you need to ensure that you're putting together a list of priority. So things that are going to be like your main government website should be your main priority to make accessible. And then really putting together a list of what that prioritization looks like. And that's really the first step is putting that together so that you have a clear roadmap on what you need to focus on first. And then it's about auditing all of these different digital services. We understand that this can be kind of a daunting task. So we don't want you to boil the ocean. We want you to focus on the most high priority services that your entity provides. And when we mean audit, I think this is a common misconception is when we mean audit, we mean manual testing and automated testing. I've talked to a ton of government and education prospects that have said that, they're just doing automated testing and automated testing is really only capturing about 30 to 40% of accessibility issues. You need to make sure that you're doing manual testing as part of this audit. That is the requirement for WCAG because a lot of the WCAG success criteria require manual testing. And this includes anything from websites to mobile apps to vendor portals. But as I said, putting together that prioritization is really the first step that you need to do. And then you most likely need to somehow engage in with some sort of accessibility expert if you don't have the internal capabilities and expertise to do the necessary changes. So there's a ton of companies out there like UsableNet that provides audits from a manual perspective, but testing tools and things like that to help you ensure that you're incorporating accessibility into everything that you're doing. Along with that, you need to make sure that the entire organization has training because we understand that so many people are uploading content and uploading PDFs, as we talked about. There's a lot of different departments that are going to be touching these digital assets, and they need to be aware of accessibility so that they are not introducing issues as they are uploading content, etc. So mapping that the where you're at and putting together that having the audit results and mapping out the conformance gaps is really what you need to do as this first step. And I'm sure that a lot of the folks on the webinar today have already started doing this. So it kind of just depends on where you are in your accessibility journey, but you do need to make sure that you're putting a strict plan together and putting together timelines on when you need to get these things remediated by.
Yeah, and I
Sean,
think
anything you want to add?
just real quick, I think just in terms of the prior slide, um, I think it's important to make a differentiation between, is the content WCAG conforming and what transactions, right, is the content serving, right? So, in other words, I think if you chase every WCAG violation, you'll be overwhelmed. So I think what's important to do is from a usability point, and this means, as Brooke pointed out, having an actual native screen reader user or somebody who's highly trained in this to go through the covered digital content that you have on your website, and from a usability perspective, evaluate barriers along the way, right? So, the individual wants to submit a license application. The individual wants to, submit a payment of some kind. Um, can the individual do that? Um, and if not, why not? And if not, what what aspect of the content is your content, and what aspect of the content is content being supplied, and who is it being supplied by? And so that process should give you a better sense of, and I think this has got to be done soon, right? In advance of the compliance deadline, right? What's realistic and what's not? And where are we headed to an area where we can say this is an undue hardship to go as far as maybe we would need to go? and then looping in your leadership to start papering that up. Because the bottom line is that for non-conformance with this, you could have an investigation from DOJ that issues penalties. You can get sued by a private party that could recover their reasonably incurred attorney's fees and get an order to make content accessible, right? So there's all these bad things that can sort of happen. I think that the DOJ has contemplated, recognizing that your resources are not limitless, contemplated certain, exceptions for you that you can take advantage of, but there needs to be thought and process around that before you can actually claim the benefit of it, right? So that's why I think that there's some thought and work that has to go into it now rather than then. I also think, from my experience in guiding like hundreds of clients in this stuff over the years, it is very difficult to do it yourself. I think that it makes sense to have an outside consultant help um, because your web development people are going to be overwhelmed with other priorities and requirements, right? So it's helpful to have an outside partner that's specialized in this very, very focused area that speaks this language of WCAG to help you get there. Because in my experience, I just think web developers have a ton on their plate. And so having that outside help is usually a core component of success. Thanks, Brooke.
Yeah. Yeah. So now just in terms of building an internal compliance framework, what does that really mean? We kind of talked a little bit about it in the previous slide, but you need to really conduct that gap analysis and remediation roadmap. Start where you fall short against the WCAG 2.1 AA, and then build the roadmap with clear priorities and timelines. We understand that you're probably not going to get everything done by May, but again, it's really making sure that you're putting that prioritization together. And then you want to assign accessibility ownership. As I had mentioned earlier, this can't just live in legal or IT. This needs to be something that is cross department, so that everyone is accounted. So people that from communications to procurement to HR, they need to be aware of accessibility, and be aware that anything that they're uploading and any content that they're putting up is needs to be accessible. And then going into more of the of procurement and contracts, like moving forward as you all are working with new vendors, you need to put language in the contracts that really point out that they need to be accessible. Whatever sort of software you're using or going to be buying from them, they need to be accessible so that that is also being covered since it is a requirement for Title II. And then lastly, just establishing policies. You need to put together policies and have, as John said, paperwork to show so that if you ever are to be in any sort of situation from the DOJ, you have documentation of the processes that you have in place, and then also have, audits and things that you can show them, showing that you're doing ongoing work. Another big misconception is that, you do an audit, you get all the remediation done, and you're done. And that really just isn't feasible because websites and mobile applications, they're constantly changing. So you need to ensure that you're doing ongoing testing so you're not falling out of compliance at any point. And you want to make sure that there's documentation there for you if you are in any situation moving forward. John, anything you want to add there?
No, I think that's it. I mean, we have a lot of questions coming in, which is great.
Yeah.
And I'm happy to start sort of digging into them. Let's see. Okay, there's a really good question that was presented here. And here's the comment slash question. 100% accessible is subjective. What disability, device, browser, testing method, etc.? How do large entities get consistent WCAG compliance results when there isn't a universal and reliable way to test? What is the best practice? This is a really good question and comment. How a website reacts to a particular browser or a type of screen reader can impact the outcome, right? So you have what are screen readers? Screen readers are software that convert visual images and information into audible narrative form. You have NVDA, you have voiceover, you have talkback, right? And you have JAWS. So those are your big three. And you also are going to be interacting with the content with a particular browser, right? Explorer, Safari, all that stuff, and Chrome and all of that. And so those combinations may result in different outputs. What the W3C would tell you is that it doesn't really matter that a web content that conforms with the WCAG is content that conforms with the WCAG, and that's going to ensure an accessible experience no matter what browser combination you use and no matter what accessible technology you use. Um, but I have had situations where a website or particular content was working great with NVDA and with JAWS, it wasn't quite as good. So as a practical matter, that's what you're going to experience. Now, in terms of what's a best practice, um, I think that what you see in the federal government, which you're going to probably see more of in the state level, state and local governments, is requirements that for vendors to do business with these entities, their content has to be accompanied by a VPAT, a voluntary product accessibility template, which is basically a form that goes over how the web property, accounting for all these sort of variations and, you know, unique aspects in terms of what you're using. But this expert that you're going to engage, and I guess you could engage usable for this, right? This expert is going to go through the content. It's going to produce a VPAT, a voluntary product accessibility template, which is published on a website by ITI, and it's going to describe whether the website or the content is performing for each of these WCAG criteria, and where it's not, it's going to say that. And so I think that's sort of a best practice to get a document like that, preferably one that says that you're conformant, thumbs up, from an expert. A VPAT's a helpful thing, and I think you see plenty of that in the federal procurement context, and I'll probably also in state and local too. But in any event, Brooke, do you have comments on that particular point? I said a lot.
No, I mean, I think one of the questions that kind of folds into that is someone asked, can you detail what manual testing really entails?
Yep, I
And
saw that too.
that is a lot of what John just said. Manual testing is done by assistive technologies like NVDA, JAWS, VoiceOver, TalkBack. That's for VoiceOver would be built into your Mac or iOS, and TalkBack would be built into your Android, for instance. And so it's things like making sure that the headings and links are clear and in order, for instance, or are the images read with meaningful alternative text? That's a huge one. You can put an alternative text on an image, but you need to make sure that alternative text is actually meaningful for the user that has a disability. Another example would be, do form fields have correct labels as well? Like you need to make sure that those are, and then things like pop-ups, you need to make sure that those are announced properly. So these are all things that any automated testing tool is not going to uncover. That's where the manual piece needs to be done.
So another question is, what if leadership in an organization prefers to wait until we get a complaint or request for an accessibility accommodation instead of striving to meet WCAG standards proactively? I think that decision wouldn't be consistent with the regulations and what the law is now requiring. What the law is requiring is that you don't wait for a request for what would be considered a reasonable modification of a policy, practice, or procedure, which was the old way. That in fact, proactively, the content needs to be made accessible without waiting for a request. There's another question that I thought was really interesting about this question of third-party posts versus third-party supplied content and how I think it may be gray. I mean, remember, there's no benefit of case law here that I can draw on. I'm just giving you the regulations, the commentaries, things that DOJ has published and my own experience and giving you what this is. There's no case law involving litigated issues on this question, and the answers may change and evolve over time. The question is this: Ray third-party content. What about content created by volunteers, such as school booster club or parent-teacher organizations? There is no contractual relationship, but there is a tacit or understood relationship between the covered entity and the volunteer group. That is really good. That's a really good question. It's sort of a gray area. Um, Okay, so like if the if the you have a loosely affiliated group that's posting on the website, right? That shouldn't necessarily be covered. That would be third-party content that's being posted. Um, but like, what if the information that's being posted is being posted in relation to a school-sponsored program or evening? And what if the school is relying on the PTA, for example, to get it information about this thing that's intrinsic to the programs that the school is offering, let's say for students with disabilities, for example, there's going to be a night where we're going to talk about, the IDEA and all these other things, right? So that's an example where I think that there would be risk not to coordinate with the third party group and say, hey, you know what, this PDF needs to be made accessible because it's really part of the program services and activities we're offering, even though we're not taking a firm hand in it. That's a gray area, but one where I think you have to be mindful of, all right, what is the nature of this arrangement, right? It doesn't have to be a contract. It could be a more informal arrangement and trigger your obligations to ensure accessible content. Another question is it expected that WCAG compliance level will change to be WCAG 2.2 level AA? Good question. Level 2.2 AA is out there. It is not in development. It is out there. I think that are we going to see, particularly in this environment, are we going to see DOJ go through rulemaking to update the regulation to require 2.2 AA? I think it's highly unlikely in this environment that you're going to see that. However, I do think that, under the equivalent facilitation concepts that I talked about, you can comply with 2.2, but I see the requirement as being 2.1 AA. For the federal government, this is sort of ironic, isn't it? The federal government, with all of its resources and power, they only have to comply with 2.0 AA, A and AA, 2.0. And you all, with smaller budgets, have to comply with 2.1. But that's because when that regulation came out, 2.0 was the main event. 2.1 hadn't been existed yet. It hadn't come into existence yet, and wasn't formally, out there. And that's the reason why 2.0 became the standard for federal government agencies. And by the way, there's been self-reporting by DOJ about their compliance with those standards, and it's been less than ideal. So this is a hard, heavy lift. Brooke, were there others that you wanted to talk about?
Yeah, and just to add, like 2.2, the difference between 2.1 and 2.2 is it just adds 9 new success criteria on top of 2.1, so it's not like you're scraping and starting all over. Um, for more of the private sector, we recommend to get to 2.2 eventually. As John said, it's most likely not going to happen anytime soon that you're going to have to meet 2.2, but we typically just recommend you get there from our perspective because it isn't that much of a lift to get there, to be honest. There's only a couple things that you need to do to get to 2.2, and you might as well get to the highest standard to make it the most accessible for your community as possible. But it's also something that can be an internal decision, is just to get to 2.1, like the requirement asks of you.
Yeah, another question in the university context. I know you do a lot of work in the higher ed context, Brooke, but
Yeah.
another question was regarding exceptions to WCAG. Would this apply to university programs that have essential functions or technical standards for an academic program, such as a program in health careers, radiography? Let's say the program has an online component, right? The purpose is to have students view an X-ray and provide information about it from sight alone. Is this an exception to have to write alt text for an X-ray image in an online course? Because there's a lot there. It's a lot
Yeah.
there. It's a really good question. Thank you for posing it. As a general matter, right, there's no carve out for, online learning. The online platform that a university has needs to be accessible, even if there are no students with disabilities enrolled in the course. We know from our earlier discussion that certain conventional documents, conventional electronic documents that are, password protected and individualized don't have to be accessible. But when we're talking about the platform of those programs, the accessibility requirements would apply. But I think the questioner here takes it one step further because they contemplate that in a radiology context, or you have, let's say, something that's inherently visual, like an X-ray, what do you do about that? I mean, how do you make an X-ray screen readable? If you're looking at a photograph of a lung, for example, how do you describe, you're engaged in inherently visual activity to identify a nodule or cancer on the lung. Does that mean that a school in that program is going to have to write alt text describing in some sort of clumsy way what the lung looks like? I think the answer is no. I think that that would be an example of a fundamental alteration or an undue burden. I think that's an instance where, the leader, the head of the department should write up the justification along with other, due diligence measures we talked about to explain how that sort of thing wouldn't be required. I think there would be a good argument that that would be an inherently visual thing. The same kind of thing comes up when you talk about like charts that are happening in real time. Like how do you convert that to audible form? These are tricky areas where pure WCAG conformance may not be possible. Where you're dealing with something that's inherently visual. May be possible in a creative way that I'm not thinking about. But that's my initial reaction to that particular hypothetical, which has like layers to it, which is what I like.
And there's a lot of questions around just PDFs. So with PDFs, like if you can make it into an HTML format, that is the easiest way to make sure that you're accessible. PDFs can be really challenging. The most challenging part about it is a lot of times, let's just say your meeting minutes, you might be like actually scanning those in and posting them online. Like that is not accessible because there's really no way a screen reader can read that. So in that instance, you could have that up, but then you also would have to have somewhere on the actual website, you would have to detail exactly what those meeting minutes entail as well. Because that way a screen reader can actually read what the meeting minutes are. So that's just one example of a lot of common things that happen is like scanning in documents, but PDFs can be pretty difficult, honestly, to make accessible. As I mentioned, converting them to HTML is best. If not, there are companies out there that provide PDF remediation and training. Especially, I think one of your comments was you have like 3 that you print a year. Like that may be something that
Right.
you would just want to
Outsource.
outsource to a PDF company. Like it's honestly a pretty inexpensive thing to remediate a couple PDFs. When you're talking about hundreds or thousands or something like that, it's a little bit different of a story. But contacting some of these PDF remediation companies, especially with the small scale, will fulfill that requirement.
There's so many good questions here, and honestly, some of them I don't have the answers for because the regulations and the commentaries don't address the issue. But it just, I think, underscores the complexity of this, and how, it's going to play out in ways, from my perspective, that are sort of uncertain right now. But one of the questions is like, could this administration, change the requirement or change the deadlines? I think to do that. I mean, this regulation was issued in sort of the waning weeks of the Biden administration. I think to do that, they would need to go through another rulemaking, which is probably unlikely. I think that it's possible that you're not going to see a heck of a lot of enforcement from the DOJ in this administration, but I don't know. I mean, the DOJ just announced a lawsuit that was bringing against Uber, so it's not dead. Although there are less people there than there used to be, that I can speak to. And so it's hard to predict in this wild world we live in where enforcement is going to go. I don't see this being a top of the list in terms of an enforcement priority, but I also don't see it just going away with a broad brush. And I also think that to the extent that the enforcement priorities change with a subsequent administration, then I think the more time you get past this regulation and the more time you're not engaging with it, the worse you're going to be, if the political winds shift in the future.
That ends today's webinar.